Good afternoon, everyone. I'll say it one more time for the cheap seats. Good afternoon, everyone. All right, thank you for coming to this session. How have you been enjoying the conference so far? Do we get a 10 out of 10? Do we get a 9 out of 10? Where are we on the scale? 10 out of 10, I'll take it. I'll take it. All right, so we're going to get right into this session. Welcome to session name Disability Case Investigation for Enforcement Professionals. What can I tell you? I can read the bio. Obviously, Gloria Richardson is known to many of us. She attended the University of South Carolina, where she received a degree in insurance and economic development. She has since held many leadership roles within the insurance industry, from adjuster to underwriting, sales, and training for major national insurance brands. She joined the PHRC in 2019 as an intake specialist and transitioned to compliance investigator. And in January 2023, she became a housing compliance supervisor. It's amazing. I was glad to be selected to introduce Gloria because I admire her. I love the way she breaks things down. She simplifies the process of investigation. You are in for a treat, and without any further ado, Gloria Richardson.
Thank you. All right. First, we're gonna, because Adrian is just a tad bit taller than I am, so I'm gonna adjust this just a little bit, It's good. All right. All right. So I'm not going to probably share much today that many of the folks that I see faces in this audience wouldn't already know. Originally, when I was asked to do this, I thought about taking a case and breaking it down that we had already litigated and found justice for our complainant. But I wasn't certain who would be in the audience besides the PHRC people. And so I didn't want to get to the point of addressing something and you might not know where we were in the course. So I decided to go back and I rethought that and started from the basics, okay? So let's go in. Did they send you the PowerPoint presentation? I just want to make sure. Yes, okay. So there's a handout that you have today, and it's not the whole presentation. I wanted to hit the presentation, just the highlights, in case someone wanted to make notes, or if you had takeaways, those were the bigger topics areas, okay? I feel it very important that you stop, ask any question, raise your hand at any time, flag down, whatever. It's interactive. Everyone or most of the faces in this crowd I've seen or known, and I may ask you to share an example of something in a case that you've had. But you don't have to be elaborate. Just share something, maybe a recent case. You don't have to say any names. But every day, the work that's in this packet is something we do every day at the PHRC. There's not a day that what we're going to talk about today we don't touch. So again, it's the basics, but it's what we do, okay? All right, so sometimes you might run into a person on the street, or oftentimes you meet someone and they say, what do you do? Does anybody in this room ever run into people and you're like, oh, I work for the PHRC? And they're like, well, what do you do? What do you tell them? Shahida? Oh, no, Todd. Oh, go ahead, Todd. What do you tell them you do?
We investigate discrimination complaints.
Okay, right. Do they normally have a follow-up question?
I have a second set.
Okay, give us your second session hit question. What's it?
I say Title VII. Some people are familiar with that.
Okay.
Federal title for discrimination in employment. And I would say employment discrimination complaints, failure to hire, or wrongful, I keep it very vague, or wrongful termination.
Right. Okay. Go ahead, she. Yes. You mean this look?
Right. Usually people know the idioms.
Yes.
And they're like, yes. I said, well, we do the same thing, but for the state, for the normal.
All right.
So they're like, oh, okay, I think that kind of.
There you go. Waylays into it. Waylays into it. All right. Next slide. Fair housing in Pennsylvania. Everyone must know that it is a right to people to have fair housing. And if you don't understand that as a basis, then you're probably going to end up on the wrong side of us. Okay? So we like to say it's a person's right, but it's our responsibility to bring that justice to the people of the Commonwealth. Okay? So, next slide, or hold that slide. What is discrimination? And let's just talk housing alone. What is discrimination? Someone tell me some examples of housing discrimination maybe you've seen or experienced. Okay. You want to tell them a little bit what steering is? Uh-huh. Oh, sorry. You got it? Sorry.
Todd, Mike Runner.
Okay, don't be throwing my Todd under the bus. Okay. Okay.
So steering, you come to meet with a realtor or something, and they're like, don't you think you want to look at this neighborhood? So they're trying to get you out of this neighborhood because they feel like just by looking at you or knowing a little bit about you, typically your protected classes, they're trying to get you to go. They feel like you don't fit in this neighborhood. We'll
All
get
right.
you into one that maybe you do.
Right. And let me ask you this, just a quick question on the side. Before you got into this business, did you know what steering was?
No.
Okay. And see, unfortunately, that's what happens. Discrimination happens to people, and they don't even know it's covered under the law. Because if you were shuffled before you got into this business, you were like, oh, okay, the realtor was really great to me, and they picked out something that was wonderful for me. And then once you get in this business, you're like, that I may look at that a lot differently. The public isn't always aware. So, when we say, what is discrimination? It is pointed out in this slide. What is unfair and negative treatments to others? Discrimination happens when people with some form of power use it to prevent others from being treated equally. The landlord-tenant dynamic, okay? The bank versus the person trying to get the mortgage. All of those are inherent that person has a power and it's something someone is trying to get, but isn't always freely given, okay? It happens not only in housing, in the workplace, in schools, in public spaces. I think probably every housing rep with the PHRC has also worked cases in other areas. Okay. What is our mission at the PHRC? Anyone want to care? Because I think Adrian Garcia is going to tell us what's our mission. Say it a little louder.
To eradicate discrimination across the Commonwealth.
There you go. All right. When we look at it in housing, we want to look at it as a two-part solution. Okay? So first, we need to enforce the law. We are a government agency, and it's our duty to enforce that law. People come to us every day asking us to look into their matter, see if there was discrimination, and if we find it, to enforce our law versus the people who have discriminated against them. Okay? And in that same right, we are also promoting equal opportunity. And how would you say we do that? So I just told you about how we enforce non-discrimination. How do we promote equal opportunity? How do we do that?
Education.
There you go. I tell landlords that call me all the time, I want to educate you before you make this mistake, because I don't want to see you on a case in my office. I want you to stop any harmful act now. Because otherwise, I'm gonna know this conversation happened, and if I get that complaint, I'm gonna know you did it. And so I'm gonna educate you now because I don't ever wanna see you on something. And usually that's a powerful message to them. When I tell them, I'm not out to get you, I'm trying to stop you from doing something that's gonna be harmful to you, because I'm gonna make it harmful to you if I get this case. So that is how we promote equal opportunity. We want to educate the public. We want to educate those future respondents, or hopefully not future respondents, to stop them from doing discriminatory acts, so therefore they never become a case in our office. Okay? Okay, as I've already stated, the PHRC does, of course, housing. We do we do employment, commercial property, we do public accommodation, and we do education. And as some of us in this room know, most of us work under multiple ones of those hats. We have cases in all of those areas. So we don't get the luxury of just being in one space. Okay? So what are some examples? And I went specifically to housing. What are some examples, and Carrie has mentioned one already with steering. What are some other housing discriminatory acts of harm that occur to complainants?
Not renting someone.
Not renting, okay. Others?
Failing to provide a reasonable accommodation for someone with a disability.
Amen, yes. And I want to say one more someone could tell me. So those are, I'm going to tell you about the big main three. What's another one? What? I'm sorry, I couldn't hear you. Okay, how is that? I don't think they can pick up on this.
Oh, I'm sorry. I didn't know we had a mic. Familial status.
Okay, explain familial status a little bit.
You know, if the landlord places restrictions on children, you know, refuses to rent for that reason,
Yep.
and other restrictions that may come along those lines.
Okay.
Familial status.
All right, and the gentleman right behind you in the blue check shirt, I saw his hand.
Advertising.
Yep. Okay, you want to talk about what would be something that was in advertising?
Advertising, excuse me, advertising using language like he just mentioned, that, you know, it's perfect for a family without kids, or things, you know, along those lines, kind of making it seem more appealing, or that it's intended specifically for a target renter.
Amen. There you go. All right, Todd, you were adding something?
Well, I mean, the generic term is your deprivation of housing based on a protected status.
Okay. What the other places I was getting at is we have a common set of cases that come towards us. Usually our number one area of protected classes, which we're going to get to in a minute, is under disability. So we get a lot of failure to accommodate. And I will get to that in a minute about how the confusion is more so around disability and how people with disabilities are treated. Okay? Our next area that we get to is eviction. So that's what I was trying to get y'all to get to, is that we get a lot of discrimination based on disability, and we get a lot of evictions, which we talked about earlier in the sessions about helping people when they face eviction. And one of the things we need to understand in that is, for us, the eviction process starts with the non-renewal. It's not the eviction filed at the courthouse or the eviction once the sheriff comes to set you out. It started with the non-renewal, because the non-renewal usually is the start of then the notice to quit. The notice to quit has to be filed to get it to court. So that's all the same process, no matter when we get it in the process, but it starts with that non-renewal. Okay? All right. what are protected classes? In this case, for us, protected classes are what made you decide this is why I was discriminated against. Okay, so that's how I want you to think about it. This is why I think this happened to me. I was in this space and this occurred, and I believe it occurred because of this. So it could be a multitude of things. It might be race, it might be sex, it might be my age, it might be because I have a disability, which is the number one thing in housing. It might be ancestry, national origin, religion, familial status, like you said, which is common only to housing. And it could be retaliation, of which I will say, retaliation is the most confusing one for folks, okay? And when I speak to that, I will say, people will say, well, I was retaliated because I was Black. Huh? And the intaker has to do a really good job of fleshing out what happened, because people really don't understand the class of retaliation, okay? So are there any of these protected classes listed on the board that the room is either not familiar with or that we can help to explain?
That retaliation part, too,
Okay,
when you said
right.
you gotta make that connection.
There you go. So for retaliation, you must have either engaged in protected activity, and let's stop there and say, I asked for something due to my disability. I went and complained about harassment. I must have already talked about something that was discriminatory to get me into now, because I did this, you did this. It's sort of like quid pro quo. I did this, now you're doing this back to me. What most people will say is, well, I was whistleblowing. Remember, I went and told OSHA. Whistleblowing, telling OSHA, not protected activity under our law, okay? So I can tell you, believe it or not, when I came to the Pennsylvania Human Relations Commission, most of the people I came in with, they had the hardest struggles with harassment, because how much is harassment? What is it? Can it be just one thing? Can it be one time? And we all clicked on retaliation. But training younger reps now, my younger reps, they can write harassment like this. They struggle with retaliation. And we're like looking, because there ain't that many years between us, and we're like, well, that's like clear as mud, you know. But that's where the struggle is. Did they do this or did they do that? And we're often talking through cases as to whether or not they're in the protected class of retaliation. But once it clicks for you, you know when it happens. Okay? Any of these protected classes that now stand out to you as something you want to ask a question about, or maybe something that you've observed? Huh? Nothing? All right. We know our protected classes. Okay. Now, Carrie is an intake supervisor, so she's barred from this. Okay? All right. I don't want you to tell me anything that happened in it, but has anybody had to file a case with the Pennsylvania Human Relations Commission? Anyone? All right, all right. I hope it was a pleasant experience. Okay, all right, all right. So, no, I was an intaker at one point, and I have great faith in our intake staff, okay? Because our intake staff, and let me step back. God bless our clerical staff. So let me start that process first. The clerical staff gets the unmitigated story from everybody, okay? So God bless them. I will tell you right now, Katie and Terry Lynn in our office, if any of you came for Terry Lynn and Katie, I'm gonna cut you with a knife. Just gonna let you know, because we're gonna protect them like Fort Knox, okay? They get that message unfiltered every day, all day long. And I know y'all know that from the Pittsburgh office. What those ladies take in every day, they probably need a debrief at the end of the day. And then that turns into them setting up an appointment for that person for an intaker. Now, I will tell you, before that person gets to an intake appointment, those ladies and gentlemen in the clerical staff have actually read them the discrimination law in their area. They've helped filter them out. They've given them other resources and places to go, that they are doing a job that I listen to them on the phone. They call me with questions. I cannot tell you how much we value those ladies, okay? But once they set that appointment up, someone calls us, they set up an appointment, that person has this unmitigated time to sit with that intaker and tell their story. Rarely in today's time do we get individual time. So inside of this process, the complainant is going to sit with that intaker, and they're going to tell them their story. Now, the intaker is going to ask them some questions, and they're going to draft them a case based on what's jurisdictional under the law. Now, we have folks, and I don't know if y'all have heard it over the phone, that they'll say, but I think you should put this in there, and it needs to say this in that line. And the intaker's just trying to guide them to a jurisdictional complaint. And they think, well, no, you're not putting in what I said and what they know it's not helping their case. They're trying to get them a jurisdictional case through. And you can hear sometimes the fight and the struggle. So again, God bless our intakers. Because again, they're getting that unfiltered story of what happened. And you have to remember, at this point, when the person comes in to tell their story, they might be at the worst point in their life. I can't tell you the countless stories I heard as an intaker. Everything from tears to, you know, I've lost my job. I don't know where I'm going to get my next meal from. I've got kids. I'm going to be put out due to rent. You're going to hear all of that. Now, the intaker gets the one-sided story. That is the only point in the commission where a complainant gets to tell their story and everything in their story is believed. Because it is just to get your story in and draft your complaint. Okay? Now, I will say, from the intake process, a lot of people enjoy their intake process. You can see that by the number of times they call their intaker back afterwards. You'll have people say to me all the time, well, I was calling Beth and I was calling this, and I'm like, okay, Beth is no longer your intaker. It is now at your investigator stage. But I was calling Beth, and I was just, Beth is not going to investigate, and she needs to go on to other appointments. But they don't understand that because they've had a pleasant time talking to our intakers. And someone has listened to them. They have taken down their facts. I mean, who doesn't want to call someone and you tell them all of your problems and your issues, and they listen to you, and then they produced an action for you? Who doesn't want that? Okay? So it's a beautiful process. And then they get to the muckety-muck, okay? And I hate to call it the muckety-muck because we, at that point, become neutral. Anybody want to explain? After you get the intake, they draft the complainant signs it, it gets served out to the respondent. Anybody care to share what neutrality is at that point? Go ahead. Wait.
You don't represent the complainant.
Yeah, give it the mic. Oh.
don't represent the client or the complainant.
Right.
Nor do you represent the respondent.
There you
All
go.
you're there to do at that stage is to collect all the facts as
you-
you deem necessary.
Right. But sometimes that's a hard transition. I've just poured out my heart to this clerical person, and I poured out my heart to the secretary, to this intake person, and they've drafted me this complaint. And isn't the next step for me to pour out my soul to the investigator? No. And the intaker tries to prepare them for that stage. They try to prepare them for neutrality. But if you're in a really bad place and this harm has happened to you, you may not be listening to, now this person's going to become neutral. Okay? So after we serve that complaint, we, under the law, are required to take and receive an answer from the respondent. They have 30 days in which to answer it from the date it is served from our office. They are allowed to ask for one extension to go up to 60 days, but no more than 60 days from the service of that answer. I'm going to speak for the commission. I would think this is so in all three offices. I'm speaking on the generality of our office in Harrisburg. Our reps do a fine job of running down answers, and if not, pursuing rule to show causes. They are dogged in their pursuit. They keep on top of it, and we rarely have to go down the road of a rule to show cause, which I'll explain a little bit more. But we rarely have to go down that road because our reps are dedicated to finding that answer, getting in contact with that respondent and saying, where's your answer? And here's what we're gonna do if we don't get that answer. So I can honestly say I maybe only had 2 cases that have gone fully through the rule to show cause and gone to trial with the PHRC. If we do not get that answer, under the law, it requires us to go after that respondent with a rule to show cause, which will give them an additional 10 days to get us an answer. If they don't give us an answer after that point, we're going to pursue it legally. And they may be found legally liable without ever presenting a case because they simply didn't answer. And our reps will explain that to people. Like, we can't look into this whether you did it or not if you won't provide us an answer. I've seen reps walk people through what is an answer, what is a sufficient answer. Here's the documentation you need. Here's our handout on answers. They do all of that work inside of their investigative process. So our reps are working hard every day on different pieces of this investigation. Okay?
Quick question.
Yes. Oh,
Do you know of any cases where the respondent could not be identified?
we've had 1 or 2 where we've, and I'll give you a recent case. We had a case against Hand and Stone Massage. And in the Hand and Stone location, this lady lived in New Jersey, but said she worked in a Pennsylvania location. And when you went to the site for that Hand and Stone, it looked like you could book an appointment still yet. But that actual location, there was no one there. And so we were like, send us your pay stub. Got the pay stub. Unfortunately, there was a select owner of like 3 or 4 of them, and they had gone through ADP. And all ADP will do is show your location where you worked. It won't show the master location. So then we had to run down who was the owner. Then to run him down at another location, because every time we got the other location on, the little girl would say, oh, well, I can't really speak about that, but I'll pass your message on. Like, no, Missy, no. So we kept going at it. We reserved that case to multiple people 5 times till we ran that owner down. And that probably took 5 months of reserving. We reserved every company that he had, everyone, until we found him. I will say, dogged in trying to find who did this harm to this complainant. But we've also, one time we had a case where this particular lady said that she was an illegal immigrant. I will say that, and she was doing cleaning work. And she said that the man running the business had sexually harassed her. Come to find out, he didn't really actually have a business. He had subcontracted himself from another cleaning service. So when they got too busy, they would call him and he'd say, oh, I'll get some cleaners and I'll come and help you in this area. He paid her by personal check. She was able to show us the personal handwritten check. He was out of an apartment in Allentown, and then he had an address in Philadelphia, and he had an address in another place, and we chased and pursued and chased and pursued, and unfortunately, we were never able to find him. And we served a lot of different locations, and at the end of the day, we determined, we think, he left the country. Now, do we fully expect that that person may show back up in the country? Yes. But at this point, we couldn't run him to the ground. That's probably one of the only cases where we could not run someone to the ground. But, I mean, out of the, 1,300 cases a year, one is and I can say that in 6 years. So we don't have a whole lot that we can't run to the ground. Okay? Because remember, we're investigators. Okay? So once we pursue and receive that answer, we've got an answer in hand, but it needs to be a verified answer. They need to have sworn that this is their right answer. And why would we want that? Like, they give an answer and they say, someone says, I've been discriminated because of my disability. And they write back and say, I don't even know what this person's disability is. So why do we want them to put that as a sworn statement? Say that again? Okay. And one of the things is that's their first step into this case. And so wouldn't you want to know that they lied in their first step in this case? Because that's very important to us, because now they pigeonhole themselves into that response. Okay? All right? So let it be known that that answer should address every line that was in the complaint. The other day, we were looking at a case, and it was an older case, picked it up, wasn't this person's case, and we realized the answer's in there, and there was 20 lines in the complaint, and it went 1 through 8, then 18 through 20. The rest of the lines were missing. And it probably had come in like back and front, but it only got scanned in as front. So we now had to go back in time and say, hey, there was a full answer, but we don't have it. So we can't move forward with this case till we get that. So that had to be pursued from the attorney, and literally wasn't looked at originally by the original rep that we had not gotten a full answer. But that's another part of the investigation, to determine we've got what we need. All right? All right. After we get that answer in, because now things are still moving fast. So they've gone to intake, they've gotten the complaint drafted, it's gotten served, they've gotten an answer back. Then we want to ask our complainant to give us something called a rebuttal. And complainants call all the time. Well, what you want me to tell you? I told you in my complaint. Well, now it's the evidence phase. Everything from this part switches over to evidence. I don't really refer to it as rebuttal. I refer to it as evidence. That's where evidence starts. The respondent can provide an answer, but usually that's not evidence. They might send you something called the position statement, and it might have evidence with it, but the answer and the document on front of a position statement where the attorney writes you this beautiful narrative is not evidence. It's just a beautiful narrative. So the only piece that I've ever used an answer and a rebuttal in as evidence is if their answer said one thing and their rebuttal and their position statement said a different thing. And then I like to point out, well, you've given us two different things. So otherwise than that, they're just narratives. Okay? All right. So we asked the complainant to give us a rebuttal. A rebuttal is, okay, here's your complaint, and now you see what the respondent answered. Now, tell us something that proves where you differ, okay? And what I'll say in that is, the complainant will say, well, that answer, they denied everything I told you. They said that I lied about this and I lied about that. And the first thing is to talk that complainant off of that cliff and to tell them almost every answer says that we get in our office. This is no different than all the other answers. So please don't take this personally. We don't want you to take this personally because we need you involved in the investigation. So a rebuttal is when they bring home the information of facts and witnesses. Do they have witnesses that support that they told the respondent something on this day? Do they have text messages? Do they have emails? Do they have anything that shows I did this on this day or told someone this on this day? Do they have a picture? Anything. The biggest thing I could tell complainants in the law today is to document what is occurring. Because at some point, you're going to need to tell someone, and you're going to need to provide a record. And that helps focus the investigation into where we're going, is when you provide us with something, okay? So our reps will reach out upon the answer coming into the office. Our reps will ask the complainant for two things. One, they'll give them the opportunity to select to go to mediation. And the second thing that they will ask them for is, can they provide their rebuttal to this answer? They actually ask them, please read the answer and provide us with the rebuttal to it. Now, some people really go at it and they do their rebuttal. Others, you're gonna have to run them down eventually down the road to try to get the rebuttal. It's important to us if you have a document showing A happened to you, then we can go look for that document on other people. But if we don't know that this document was given to you, then we might not know to go look for that. So we're trying to get nuggets from you to help us guide in the investigation to prove that this happened to you because of the reason you said it did. Okay? So we want that rebuttal. Anything you can give us, we will pursue it if we can find that adds to your investigation. Okay? I mentioned at that point that they're also offered mediation. So you want to go to the next slide. We have decided within the last year, matter of fact, last April, that we would offer both the complainant and the respondent the opportunity, once the answer came in, to attend mediation. That form goes out religiously. In our office, every Monday, the supervisor runs a report. It should already have gone if you got the answer in the last week. If you haven't, it's sent on that day. And that offer goes out to both parties. If both parties agree to mediate, then that case will be taken out of the investigative wing and sent to our mediation team. We have both Chris and Mila, and they are scheduling 3 to 4 mediations a week. and they are mediating cases, trying to bring the two parties to solutions similar to what you may have heard earlier in the presentation in the morning session. So if they can, that case will be mediated. If they can form a solution at that mediation, then that case will be settled, it will be signed, it will be confidential, and the case will close off the investigator's desk. It is still on the investigator's desk, but they cannot see any of the confidential mediation that is going on. Those notes cannot be seen, okay? So, but if it fails in mediation, then it's gonna come back and go back into the investigative track. If the parties decline mediation, it's gonna stay on the investigative track, okay? All right, active investigation, and the word active is the important thing. So, how many investigators are in this room? Okay, all right. When we say active investigation, if no one minds, not throwing anybody under the bus, what's the oldest starting year of a case that you have in your pending or in your district? Anybody want to say? I can start out.
22.
You have a 2022. Okay. Anybody have a, no one has a 18, 2019, 2020, 2021? Okay, all right. We have a rare strange bird from 2018, and it's a reopen with against Durham Bradstreet, which is an odd thing to deal with. But by and large, most of our reps are in 2022s. I think I might have less than 2022s left, and they have started hard into their 2023s. But that was, last year was a push to let's get those 2022s out. And I need to bring into account for non-PHRC people, our year marker on claims don't run consecutive with the year. So in July of this year, we will start writing cases titled 2025. And I know when I came to the commission, I was like that, why am I doing this? Like, this doesn't make any sense. But whenever that started, no one ever told me the background of it, but we don't start till July 1st drafting the current year's cases. And so that's why when you see someone, when I say they're drafting a 2020, they're handling a 2023 case, it might have been done in 2024. But that's how our case number system goes, okay? When I say active, and this is probably the biggest pushback for us with complainants, is because until this point, everything has gone fast. And we get you to a point of hurry up and wait. Because we've done all these things. You've gotten an intaker, and they've been upfront with you, and they've drafted your case, and it's gotten served, and you've gotten an answer. Now we ask you for rebuttal, and then they're like, okay, what's next? You're gonna wait. Because now we put you back in order of cases received. And now they're worked in order that they're received. The only thing that gets a case out of the order they received is if they are situated as a priority case. Housing is priority, all housing. All education is priority. In the employment area, we will take some cases and move them up. And what I mean by that is, if you're over the age of 75, we're gonna move you up. If you have a terminal illness, we're gonna move you up. Last week, we got a call from a woman, and it was weird, because this was just it. She called last week to tell us, I just got diagnosed with stage 4 cancer. And how strange it was, is that it was due to be on the audit for the rep the very next month, for this month. It was like, oh my God, like we would have been working it anyway that month, but now she's the first one out of the batch. We're looking at those things, and we want to take that information. If we know it up front from intake, it will be coded from the very front so that the supervisor will be aware that it exists, so we can move that up. Okay? So for us, I'm going to ask Jody just real quick. Jody, what's active investigation?
I can talk.
Oh, yeah. What's an active investigation? What starts an active investigation?
RFI
Okay. And
and the interview.
there you go. And when Jody tells them to actively interview. That's what I was trying to get Jody to say when I tell them.
That's a given.
That's it. There you go. Okay. So every month, the reps at the investigators at the PHRC, they are assigned a number of cases to start active investigation on. And that is assigned from their supervisor. So they're not going through their pending and saying, I like Joe, but I don't like Susan. There's none of that. Like I said, those urgent cases take priority, and then it is oldest cases. Because we need to get those cases worked, or they're gonna just sit there, and they're going to linger. And then sometimes, there have been past times where people have plucked around pendings, and then those cases are there. Oh, it's got a lot of counts. I don't know. It's got a lot of work that's going to be done. No, we can't allow that to happen. So the supervisor and the rep work together every month to determine what cases they're going to write, and they're given that information. You have your supervisor on hand to work with you on any cases that are difficult, okay? So to me, whenever I say an active investigation, it's a case that's assigned for them to start working, okay? So now I've asked them, and I've talked to it about it before, I asked them, or asked the complainant, to give us a rebuttal. Okay, there's a lot of times, a rep will be assigned an active investigation. They review the case back, and they realize the complainant never gave them a rebuttal. They are going to write something at that point called an investigative plan. And the plan is just a living, breathing document of this is all the things I have at this point in the investigation and all the things I think I need. So that's, when you think plan, that's all I want you to think of. But they're writing that, and part of that plan tells first, what does the complainant say was harmed? What happened to them? Then, what did the respondent say they did in reverse? Did the respondent provide did they say, one, did they say, oh no, we didn't do it? Did they say, we did it, but we did it for a different reason than what you think we did it? That's called, are they presenting a non-discriminatory reason why they did something? So, for example, what did y'all, if y'all said in the morning session with the group that was upstairs, they said something that 85% of all the evictions were due to non-payment of rent. Okay. Is non-payment of rent a discriminatory reason to evict you or a non-discriminatory reason to evict you? What'd you say? Okay. maybe do mine.
Non-discriminatory reason.
Yeah, she said non. Okay. So, because remember, the rental contract says, in exchange for your rent, I give you housing. Give it a mouth.
Pearson here brought up a good point, because if they're not applying that eviction policy equally, so
Right.
if, you have your Asian tenant who doesn't pay their rent and they get evicted, but then you have your Caucasian tenant who doesn't pay their rent, but they never got evicted, or, nothing happens to them, it could be discriminatory.
That's right. So that's what the intaker is talking to them about in the complaint, because they may say, I didn't pay my rent. So intake doesn't cut them off there. They then will ask them, well, did anybody else get evicted for not paying their rent? Because, ladies and gentlemen, we're in the comparison business. We need to know if that's a bad landlord or they have followed the law. And so we will investigate their actions inside of that. And 9 times out of 10, when someone really thinks something has happened to them as a harm, and they firmly believe it's because of their protected class, they will be able to articulate it didn't happen to them. And here's how we are different. So again, that would be in the complaint, and therefore should be in the answer. So see how we're, again, everything is in writing, back and forth, and why they say they did it. Now, if, say for example, they said race, okay? I was evicted because I'm African American. I don't think that they don't evict people who are African American. Well, then we can do one good simple thing on that. We can check all their eviction records. Then we can find out the race of all those people. Is there some trend analysis or data that shows all they do is evict African Americans? Or are they evicting people not paying rent of all different ethnicities? Because that's what we're looking at. We're looking at is their actions focused on the protected class. And sometimes, in the rare form of the bird, we may prove that it's not race, but then we find out it's age. And the complainant didn't ask for that. They didn't think it was that, but we find it is. And do you know what we do then? We go amend that complaint so we can get them for what they did. So that's why we're investigating and digging, because it might not be the thing that they say, but we find something else. So, but if we don't do the deep dive, we never find those things. If we do surface level work, we don't find the things we need to find. And I can tell you, we probably don't find all that we could because we don't have months to sit on one case. We don't have a year to sit on one case. And I'll give you an example on a case that we had the other day. Okay? So, after we're writing this plan, we also, and I'm going to come up forward and we're going to talk a little bit more about it, of something called a proof formula. It's a guidance of how we're writing that plan. And we are going to do all of our interviews at this stage. We are going to request documents. In that plan, we're writing, here's what we have. And again, what do we need? Okay? When an investigator at the PHRC writes that plan does not become concrete. That plan goes to a supervisor. The supervisor may see it the same as the rep, they may see it slightly different, or they might see it completely different. That is 2 different people looking at the data and trying to come to the solution. It may also be, hey, based on experience, I think you should take these steps, and those steps are added in. Now, in the Harrisburg office, doesn't always happen in that, but in the Harrisburg office, after that supervisor has looked at it, it goes on to the regional director. And they look at it. And sometimes the 3 of us aren't on the same page. We might get legal involved. But a lot of times, the supervisor and the regional director have seen it enough that they know things to go look for. Or the complainant provides us with something that we're like, we need to go right there and take a look. And we devise which ways we're going to do to get the information that we need. Sometimes it's just simply a request to the respondent. Sometimes we don't involve either the complainant or respondent. We go out and do some independent investigation, which is the best data in the world. because nobody provided it to you, you went and got it yourself. And sometimes it's public records. In employment cases, I've gone and pulled civil service records and civil service complaints where they've got sworn testimony. Or you might pull it from unemployment with testimony. In housing, you might go to magistrate's court and pull the records from the magistrate court of when they went to the hearing. What did they put in their filing that they say that they did? What did the complainant say? What did the respondent say? There's a multitude of evidence out there that sometimes we can put our hands on that we don't need either the complainant or the respondent to give us. What now?
Because it's under oath.
There you go. All right. Witnesses. At the PHRC, when we statementize a complainant, we don't do that as a sworn statement. But everybody else that we do, we want it as a sworn statement. Because somewhere down the road, you may be called to testify. And we want to provide that to our legal staff because we're ready to defend it. We're always preparing that case for a potential PC, and we are preparing it if we have to defend it. Okay? Okay. If we do a request from the respondent, and nothing burns me up more than to ask for 1 or 2 documents that you've told me you had, or you've mentioned in your position statement that you reviewed and they've got, and then you can't produce them for me. We could be done with this case, but we're not done with this case because you're not providing us with what we need. So that is one of the beauties of our job. And I'm sorry, maybe that sounds sadistic, but I gather great pleasure from subpoenaing you. And I gather great pleasure from handing it to you directly. I have no qualms at sending the subpoena threat letter, and I have no qualms in following through getting that subpoena. I have no qualms at showing up at your door and serving that subpoena. We have that ability from our rights under our act and from the governor, and I take that seriously, and I try to imbibe that into my reps to be serious, because this is a power that everybody does not have, and we need to use that to find justice in this state. Okay? Right. After we write that plan and it's approved, that's the roadmap for our investigators to complete that investigation. And they'll follow that roadmap unless they hit a bump in the road. And that bump in the road is something new comes out of the evidence that says I ought to go somewhere else. Okay? And so that's why it's important to teach reps how to look at and interpret evidence. That's when you know you become a good investigator. If you can read, and sometimes people will just send you stuff. Ain't got nothing to do with the case. How many times has it been a 1-count case with a policy and they send you 15 policies? What'd you say? Needle in the haystack. There you go. And they want you to have to search. And I tell my reps, don't get frustrated. Just go pick out the policy that you needed. Set the rest of the stuff to the side. We're going to the evidence that we need. They don't know what we're looking for. So we're going to go for what we need. And if they didn't provide it to us, we're going to ask again. And we're going to keep asking until you give it to us. And if you don't, we're going to subpoena it. Okay? So that's the thing that you need to know, that we've used this investigative plan as a framework till we find something different. Case in point, we had a recent case where a woman joined the public defender's office as an investigator. And this one took a little bit of a twist. And she says, I was hired in June. My coworker was hired in July. He started $6,000 more than I did. And I don't know why. Ever since then, we've been on a union salary grid. So we've been paying. But I can never make up for the $6,000 extra that he made before I did. And so she filed a case that said it was wage discrimination based on sex. So out of the beginnings of that, that sounds weird, doesn't it? They got hired to the same job for $6,000 different. Anybody care to explain or say what could have made a difference? Because I'm going to cover it, but anybody care to share what might have made the difference? Okay. Okay, yeah, can't hear y'all, the answers, so I gotta say it. Hurston, she knows this case. That's okay, that's okay,
Education
that's okay.
experience.
This is a good learning case, though. That's okay. Go ahead.
Oh, I said education and experience.
Okay, all right. So, and it was okay. That's okay. So, out of this case, when the rep wrote it, the rep who wrote it, not normally, this is not her area. Okay, so it's okay. No. Yes, yes. So the rep wrote it and compared the complainant to this gentleman who started a month later. In the midst of the notes, though, there had been another male hired, and that gentleman made more money than her too. And the rep didn't catch that. Okay? So, but the comparison was between the first gentleman and her that were hired a month apart. Okay? So we write it, we looked at all of their EPRs, and in this case, I'll just say it, she had been a paralegal, and the gentleman was a police officer. They'd been retired from their field, and they came into the public defender's office to be investigators. Now, out of that, they used, and we got all the records of when the person posted the job, and they went in front of the salary committee as to what they wanted to hire these people in. Both were hired at a higher rate than a new incoming investigator would have been hired at. It's just she came in at a grade 4, and he came in at a grade 7. And they used, like you said, experience, that he had been a police officer and she had been a paralegal, and they had experience.
I actually have a question when you're
Okay,
finished.
go right ahead.
As a complainant, what would be ideal for me to provide you with the adequate information, given that I may not be privy to internal hiring decisions?
Okay, so are you talking about for like a failure to hire, or either I was hired in this case and something went on? Okay.
More where I need comparators.
Okay, okay. Under the failure to hire, we never make a person tell us a comparator. How could they? They didn't get hired there. They don't know who got hired. We will investigate all of that. We will pull all the records on all the people that applied for the job, all the people that got interviewed for the job, and who eventually got hired. And we will compare them to the complainant. Now, in this case, she got hired as an investigator. And I'm just going to give you a little bit of facts. There were only 4 investigators in the office. So there wasn't a big population to compare her again. And I'm going to also tell you, she was the only female investigator. Okay? So all 3 of the others were male. And so and I will just say, all 3 males made more than her. So on the surface, that looked like, ooh, that's not good, okay? But when you went to now the one gentleman had been there for years. So he kind of was out of the population. He had been there for so much longer than any of these 3 people. And so we started looking at, okay, well, why did you bring her in? And the supervisor had all these write-ups of when he went to the salary board and what he'd put them in on. So we had all of that. I saw it, and I'm going to, Kristen won't know this, but this story touches on something that was personal to me. So that's why I saw this in this case. So we closed it down because they said it was based off of experience as a police officer, and she did not have that, okay? In writing it, I probably could have had my rep write that better to get to my lived experience, but it's okay. That's okay. So Kristen, our complainants, once we close a file, can appeal it and say, I don't think it was investigated properly. And it went in the appeal, and it went to Kristen, and she read it, and she's like, no, I think y'all missed something. And that's okay. That's her job. And it sent it back to us to look at that second gentleman that got hired after her, who also was a police officer. And when we dug into it a little further, and I hate to say this, but I kind of, and I'll tell you my personal story. That's why I will say I kind of knew this. Come to find out, she was at the jail. She would interview any new person that came in and had committed a crime, unless they committed homicide. Then these two gentlemen did the homicide ones. They also went out to the scenes of the crime and did the investigation out at the scene. They also were the ones who went to court with the attorneys when the case was prepared. She was still there in intake and process. She did an integral role, and I hate to say this, she had strong organizational skills. And before they had her, they appear to have had people doing all of the job, and things were falling through the cracks. She ran a tight ship. And in every one of her EPRs, you could see they were like, thank you for taking this on and for handling this and making sure this is always done for us. And they were praising her and giving her great reviews because she was taking all of that piece of the job and doing it for everyone, which then freed these gentlemen up to go do that piece of the job. And when we got their job position reviews, they actually, even though they had the same title, had totally different functions. Now, I'll use the example of here at the PHRC. We have HRR1s and HRR2s. Doesn't tell you who's the intake, doesn't tell you who's the investigator. They're just HRR1s and the HRR2s. An intake job and an investigative job, different jobs. CROT job, HRR2s, totally different from what an investigator or an intaker does. We can title people under the same job. It doesn't mean that they do the same. Now, if I had my way, I would have told Lancaster County, you probably should shift what you call them, but so. And the reason this was personal for me was straight out of college, I had gotten a scholarship from an insurance company, and they wanted to come and show me around. So I'd been interviewing to come out of college with a job, and they brought me over and they toured me around their headquarters and blah, 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 blah. And then at the end of the day, I sat with the vice president. He said, are you interested in any of those areas? And I was like, yeah, I kind of am. I'm interested in claims. And he said, okay, we'll hire you. I'd never had an interview. I was offered a job. It was 7 minutes from my house. Good, reputable company. I went to work for them. And it wasn't till the very first week that I worked there that I realized that they had made me an inside investigator. All of the inside investigators were women. All of the field reps were men with company cars that you were supposed to take everywhere you went, and the company paid for gas. But we made the same salary, and we had the same title. But you don't know that sometimes. You don't know that when you walk through the door. So, me, I don't care, I speak up. What's this all about? And they're like, oh, last woman we hired to do this field adjuster job, we found her crying up under the desk. And I said, really? And they're like, yeah, it's Beth. She's upstairs in underwriting now. And I said, ain't nothing you can throw at me gonna find me crying up under a desk. I'm not made like that. And he's like, oh, I don't know. Whatever. Okay, sure. So it took me a while. I started training field reps. They would come into me, I would train them to investigate, and they'd go out in the field. So my boss was like, okay, this is looking kind of bad. This is looking really bad. So he went to his boss and he said, the next open field job I get, I need to offer it to her. And he came to me, he said, would you be willing to move anywhere? And I said, yeah. He went in there and he said, if you don't give her this next job, you can fire me from my job. You never know what people say behind your back and what they do. And so I've been filling in, doing work for field people, and so he put me out in the field, and that next year, I was Adjuster of the Year. I could run circles around other people because I knew what I was doing, but I couldn't have the opportunity to go out there and do housing and do, diamond inspections and different stuff if I'm not given the opportunity. So I understood this woman saying in this case, well, why am I starting out less? I'm doing this work, but you also, if you don't know that they're doing something different, because they weren't in the same building with her. She goes, oh yeah, they're over at the cushy air-conditioned building. She doesn't know what they're doing. Because we were like, surely she knows what's there. She didn't know. So sometimes we don't know what we know, and even if someone bought it to you, you might not believe it. So maybe you have an outside party investigate to make sure that's true, and that's the law. So we did. We reinvestigated. We pulled that information. We talked to her. We were confirmed. She had no clue that those gentlemen were doing these items and why they had used their skill set to give them more money to go do those things. But she knew when they came to the jail, there was a certain level of case that they worked, and she did. She knew that. But that was the only piece she knew. So once we get the proof formula, and once we look at what harms they had, we're going to choose a proof formula based off of what they say their harm is. If they say that they didn't get a reasonable accommodation due to a disability, we have a proof formula for it. And people will say, like, what's the proof formula? A proof formula is line by line things that have been tested by legal precedent as to what we can do to prove a case or not, okay? So we have a roadmap, and the EEOC uses that roadmap, HUD uses a roadmap. We're using the same proof formulas to try to prove those cases because we know we may end up taking this case to court. So that's what we're preparing for every day. It's our job to run with the ball, to hand it off to our legal department, okay? So when we review that evidence, our reps will go through it, and anything that they don't understand or can't grasp, that's what the supervisor's there for. We're gonna look at an infinite amount of data and try to interpret it so that it makes sense. And if not, then we need to be on the phone or in person talking to people and making it make sense. I had a rep once say, well, he says he's a sales director, and I don't understand these reports that this complainant sent me. And I said, well, guess what? You don't have to be a subject matter expert on that. Ask him. He says, these are the reports that I cover in my job. Have him explain them to you. And they're like, oh, okay. That's what we do. We're going to get our answer from either one of those parties to understand the data that we've got, and we're going to put our noggins together, okay? All right. After we've looked at everything, so we've looked at the act of harm, we looked at the discrimination, so we're going back to housing. So you mentioned earlier, say we've looked at an eviction, but what about, and it's the pesky ones of terms and conditions, okay? So terms and conditions implies a policy. They're saying, basically, I was treated differently than others. And I will say 9 times out of 10, it's usually something to do with their maintenance. So you may have heard that early this morning. Concern about, I made these maintenance requests and they're not getting followed through on. Okay? So, when would that be discriminatory? The complainant has made a complaint that their maintenance requests are not getting handled, and they turn in a complaint to us saying it's because of X. When would that be, when would we find discrimination in that? Anybody want to take a hit?
When other maintenance requests are being handled by other tenants?
And they are not X. Right? Okay? So it shows some preference for not getting maintenance requests done. So how could you find that with evidence? Okay. Right. Uh-huh. That's okay. Go ahead. Yeah. Okay. 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 Thank you. All right. So usually each landlord has some method in which that you will turn in a maintenance request. So for us, maybe we want all the records on your maintenance request, because then we can go through it, see how timely you are responding, or are you not responding to anybody? And then of the people you're responding with, what is their protected class? What's their X? And is it different than our complainant? Or is it the same? So that's what we're looking and digging at. It's a comparison of the information and the data. Can we prove that this happens? And then did it happen because of the protected class that the person is in? Okay? I'm going to go quicker through this because we have time. I put in there, if you'll roll through them, there's a couple and they're in your handout, just some common proof formulas that we use in our investigations. They're in here so you can actually see them. So I'll go through. Okay. Once an investigator has completed the full proof formula, they need to determine whether or not the respondent was probably discriminatory or not probably discriminatory. We call that either a PC case or a non-PC case, okay? A non-PC case, or no probable cause, is that we have found insufficient evidence to support that they discriminated against our complainant. And that means either we could not prove it, or we found definitive evidence to show it didn't occur. Okay? It could be either one of those. Okay? A probable cause case, and let me step back. A non-probable cause case, we're going to close the case down. We're going to send them a letter of finding of non-probable cause. It will have a write-up in it, and at that point, the complainant will have the opportunity to appeal it. If we find probable cause, then a totally different thing occurs. Because as I told you before, we were neutral. We are neutral right up to the point where we find discrimination. And then we are all on the complainant side. We are no longer neutral. We are bringing this case on behalf of the complainant. And we will issue a finding of probable cause. And from that probable cause finding is a requirement to do a conciliation and to attempt to settle this probable cause case for damages awarded to this complainant. A lot of our probable cause cases settle at this conciliation. Just had one last week, respondent didn't even show up for it. But I would say, maybe 8 out of every 10 I go to with me or my team, we settle. If it does not settle at that conciliation, then it is going to go on to our legal staff. It is going on to either Robert or Kristen. Like that case last week, that's going on to Robert probably. So, but it should be an easy one. I will say that. So, but they will defend it, and we've had great results. If you ever want to check out those cases, they are at our phrc.com website, and you can see all the cases that our legal staff has litigated over the years. All the results are listed there. Okay? All right. Out of this, one more thing we want to talk about is we will, and if you'll go all the way down to potential remedies, I'm just going very quickly. It's next to the last slide. Out of that, our complainants, once we find that probable cause, there's a multitude of things that they may need to ask for. It may be moving expenses. It may be medical bills because they've been traumatized by this. It may be a multitude of things that only happen to that individual. And that is the time to bring forward what has happened to them, how have they been harmed by this, and what can we do to remedy that. So everybody's remedy is not the same. None of us are the same, so our remedies might not be the same. Sometimes you'll be amazed. Some people want just an apology. And then you have the other person who wants $6 million. And you have to tell them you probably can't get them $6 million. But, you know, it's a multitude of things that are in there. And you're never going to know, but you have to tell people, okay? So you can look at that. I did include that of different potential remedies in your packet, so you could have it. We do have one other opportunity where a case may close with the PHRC that is not either a probable cause or non-probable cause. I've talked a little bit about settlement. So settlement is an opportunity. Anytime in the life of the case can be settled between the parties. And that settlement can include the PHRC, or they might exclude us. But we will help you settle your case if you want to settle it. Other things is, we may also find that once we begin to investigate the case, we find some reason why it is either non-jurisdictional, and therefore we can't take it. If there is another remedy or opportunity for you, we will send your case forward to that opportunity, or let you know you might want to go pursue here. It might be untimely, again, a jurisdictional issue for us. If at some point in the life of our investigation, the complainant decides they want to go file in court, whether it be state court, federal court, court of common pleas, whatever it is, if they decide they want to go file it legally in court, they've taken the remedy out of our hands and decided to pursue their remedy that way. Therefore, we would close our file, okay? Respondent is bankrupt. You heard the old saying, can't get blood out of a turnip, okay? We've had one of these or two of these recently where the respondent has gone out of business. What can we pursue for our complainant? Now, we confirm that they're gone and make sure, but we can't pursue any further. If the complainant cannot be located, we cannot bring any cases on behalf of a complainant we can't locate. We can't investigate for a complainant that won't come forward and help us, okay? Complainant is not cooperating. We will try things. We will try to run different reports, look at emails, text messages, whatever we can do to try to get you to help us. We have even called people and said, hey, we have money on the table that respondent wants to offer you. Can you please come forward? And believe it or not, people will not come forward. I think the largest one in our office at one time was like $75,000. And they had to close the case because the complainant just would not come forward. And you think that can't possibly be, but we had that at times. Appropriate remedies were offered and either the complainant didn't accept. The complainant gets offered something and it is what we consider full remedy, and they just don't accept it. They offered them $50,000 and they wanted $600,000. Probably not going to meet in the middle, but we consider that full remedy. Ladies and gentlemen, that's the end of the presentation. We only have a few more minutes before us go. Is there any question or scenario that you've got that I can answer for you? I will be more than happy to do so. Anything? Yeah? Because I don't want to stand between you and here and the end of the door. Okay, hold on one second. Oh, I know. Your day is almost ended. All right.